2017. I take this opportunity to thank the community if they wanted to come out to review this meeting today. It's our opportunity as your elected representatives to collaborate openly and make decisions that will decide the future direction of our public schools and the education of our children here in Clayton County. There will be an opportunity for the public to ask questions at the end of the workshop presentation. Your participation is welcome and appreciated. The purpose of today's workshop is for the members of the Clay County School Board to interview candidates for the position of school board attorney. Pursuant to school board policy, members of the public will have an opportunity to speak and ask questions of the board during the section of the workshop titled Questions from the Audience on our agenda. Today we will be interviewing two candidates. The format for today's interview will be as follows. We will introduce ourselves to the candidate, and we'll ask the candidate to introduce themselves to us and give them approximately 5 minutes. We'll then ask 10 preliminary questions of each candidate and allow them 3 minutes to respond. And we'll rotate through the board members. And just let me finish reading, then we can discuss. Once the preliminary questions are completed, we will open the floor to individual board members to ask any questions, any additional questions they may have. And we, again, will rotate that so that every board member has the opportunity to ask questions. And then at the conclusion of the interviews, we will ask the candidate if they have any questions for us before they exit the room. So before we bring the candidate in, Ms. Gilhousen, you have.
Yes, I would like to request that we strike 2, 5, 7, and 8 from the rubric. I'm fine if you want to ask those questions yourself, Ms. Garrett, but I don't want to give weight to those on our official rubric. In my opinion, they reflect what your priorities are as our school board attorney, but they don't necessarily reflect my priorities. I can't speak for my other board members, but I felt like those were a little...
Okay, I appreciate your input. I will tell you, I didn't write any of these questions. I was thrilled with Andrea Messina when she sent them to me because I think they cover every area of educational law that a school board attorney would need to handle. You have been on the board only 2 years and you have not had
Okay,
a school
hold
board
on.
attorney. No,
We're not
please-
going to get into
Please
personal
let me tell you
insults.
what I'm about to
No,
say. I'm not
that is a
insulting you.
personal
Yes, you
insult.
are.
No,
You
that
are
is a
insulting
personal
her.
insult.
Ladies, please just
I have
let me
had
finish
every
my
bit of
thought.
training.
You don't
that
let
you
her
have had
finish.
as
You
a
don't let
school
her
board
finish.
member.
Betsy, please stop.
Don't call me Betsy, it's Miss Condon.
Ms. Condon, please stop. Ms. Gilhousen, my point is we are still a relatively young board. I'm only 6 years. Mrs. Studdard is the one with the most experience. So we have not had to deal with everything as a board coming to us that the attorney does. And having had a part-time attorney here for the last 2 years, there's a lot that has to be outsourced right now that he's not able to handle. Maybe he doesn't have the time because he is a part-time attorney.
I don't understand what the relevance is with what you're saying right now because the questions I'm asking you to strike have nothing to do with outsourcing.
Oh, they
So-
absolutely do. We need a school board attorney. Number two, we would not be doing our due diligence if we didn't ask that of every single candidate. How much experience do you have? Have you ever worked in a
I
capacity
agree
as a
we should
school
ask that
attorney?
question. I don't agree it should be on the rubric.
Well, I think it should be. And I was
Because I
thrilled
don't
when
believe
she
that
said this.
your questions are any more valuable than mine are.
And you will have the opportunity to ask your individual
But my
questions.
questions will not be on the rubric.
There is a rubric behind there. If you look through what Mr. Brodsky gave us, additional questions, we can write in as many as we need to.
Right, but they're not on your sheet. Are you going to score my
I'm going
questions?
to score yours also, absolutely. I think every question that's asked, we should write it down and score it. That's my intent. Your question is just as important as Ms. Follis and Ms. Condon's and Ms. Studdard.
Well, the initial process and the way that this was developed doesn't reflect that, in my opinion. This feels like it was crafted for the board instead of crafted by the board. And this is our opportunity to hire and interview, and I feel like my opinion has not been valued in this.
Can you honestly tell me that you don't feel that question number 7 is a valuable question?
Yes, I can honestly tell you that I
Right?
don't believe
So you don't
that
think
is.
it's important to know?
I'm not saying that it's
if
not a
they
valuable
handle-
question. I'm saying it's not fair to grade it on the rubric in a way that penalizes someone who doesn't have the same experience but may have an alternative experience that's just as valuable.
Madam Chairman, may I say something? It sounds like, I understand where you're coming from and I understand what you're saying, but I really think it's a good point because what she has just said is that the additional questions at the end they will be on the rubric and be graded. So it really, there's no point in y'all getting into this discussion right now because everything is going to be graded on the rubric. And so, you know, this by having additional questions, I think that'll cover anything that you feel isn't covered in the other.
Well,
So
as long as we agree that
I
we're
think
all
we
going
need
to
to
score all of the
work
questions.
together to try to find the best attorney for this school district and try to do it in a collegial
I
manner.
agree.
This dissension and bickering needs to stop right now before we get started.
But Ms.
It
Studdard,
didn't start today.
Ms. Studdard, you actually were the one who started it at our first workshop about the school board attorney. That's where we should
I
have.
started what?
You started the dissension because you attacked us about one particular candidate that wasn't on the three of our top fives. We each have the same vote in this process. We each get one vote in the process. And where the whole process should have been flushed out was at that workshop. How the workshop was going, or how the interviews were going to be conducted, how the room was going to be set up, how we were going to talk to the individual candidates. All of that should have been a board decision. That vote has left the harbor because it's done. And Ms. Karakis said she decided how the room was going to be set up, and 2 board members walked in today and said, oh, I thought we were going to be in a round table. Being the chair of the school board doesn't say you get to decide how the room is set up. It's simply to work with the superintendent to set our agenda and to facilitate our meetings. That said, I reserve the right as a voting board member that my rubric may not be scored the same way that others, because I would like to weigh different questions in different ways. And so I may not even score some of the questions that are on here. I have other questions that I got from the American Bar Association and the National School Board Association that I feel are more relevant to what I'm looking for in an attorney. And I do feel like from that initial workshop 2 times ago, Mrs. Bola raised concerns with the process, and I feel like you made some valid points that were not addressed in trying to manipulate the outcome of this session. We actually had some candidates withdraw from the process because of, I believe, because of what happened at that workshop. So now for you to say we need to work together, I agree. I said that night we needed to work together and that we all needed to, I hope it comes to a 5-0 vote, but I do feel like this has been forced down our throat instead of spending, we've had 2 workshops now where we had the opportunity we could have come up with crafty questions. We could have looked at these questions together on Tuesday, and you chose to not send them out until after 3 o'clock yesterday afternoon when I sent an email asking for them. I think that is out of line because it felt to me like you wanted someone else to be looking at them and crafting them instead of our board. And at the end of the day, the decision comes down to the 5 of us board members. And that's it. It shouldn't have outside influence from other people. I've been getting emails in my school board email about one particular candidate, and I didn't realize that who our candidates were was public knowledge. So it's ironic to me that that people would start sending me unsolicited emails about candidates. But that said, that's where we are. But in transparency, I may not even score the rubric the same.
I think we need to move this along. I heard what you said. As far as the room, I can't believe that you're quibbling over the setup of a room. Every time we've ever had a workshop in here, this is the format for the setup. Why should today be any different? We are the
It's a job
board.
interview.
We are the
That is what I
board.
wanted.
You were the, I'm sorry, but Ms. Studdard, you and I spoke, well, in the general forum, you were saying, it's nice when you can sit around a table and meet these people and have an agenda.
I meant this rather than in
This is not something.
No, not in the teaching training center, in a more intimate.
This is more.
Well,
intimate.
but if we had been if we had swept these tables around and made it 4 tables and all of us were sitting around and able to talk and able to listen and able to embrace this person as whoever the candidate
You
is.
can't talk and embrace him, her.
When I walked in, I said, oh, it's the Grand Inquisition. That's exactly what my impression. I've done job interviews, that's the way I would do it, but that's, be
It was
that
not
as it may,
intended
it's
to be-
9:15.
It wasn't
It-
intended
this
for any
is-
reason other than
No,
this question.
excuse me, it's
Ms. Fuller,
9:15, we have an
please.
hour.
Please, let me finish what I was
These
saying.
people are waiting.
Yes, they are, so let me finish. Miss.
It is.
Miss-
You're absolutely right. It is embarrassing.
Ms. Condon, to your point about the questions, and something I want to remind everyone, Ms. Gilhousen, this was not my questions, this is not my agenda. They honestly call out to FSBA, Andrew Messina could tell you, she gave me these questions.
Hey,
I sent them to Mr. Brodsky to put a rubric together because that's how the scoring is done. But we've never done interviews before, and something that she brought to my attention, which Mr. Brodsky
let's
confirmed to
backtrack
me.
that. You've never done interviews before.
Have you hired a school board attorney?
I've hired employees.
Have you
I've hired
hired
several of
them?
them.
Well, I've done interviews.
Dozens of employees.
But I'm talking about us as a board hiring a school board attorney. So I think what Mr. Brodsky put together is so impressive, and I just want to thank you for the rubrics, because I think you did a good job with this. This is really well. However, I was told that everything we say, we write, everything we do today is a public record. And it was explained to me by Ms. Messina that it's not the same as our regular school board meeting where we can just talk. And she said, and especially since we don't have a school board attorney here today, she said, be very mindful and very careful of questions that you ask, that you don't step in any potholes that could come back to some kind of litigation.
That's why Mr. Brodsky's here. I hope
And she
the
said,
word is off those questions.
we do need to turn this, and we don't have to turn it in today if you want to take it home, reflect over it. You know, you want to write your notes and then do a grading at home after you rewatch the interviews. We should get them back to Mr. Brodsky by maybe Wednesday of next week, because we do have to preserve everything that is written. If you write something in one of your notebooks, you have to give a copy, because if any of these candidates should want to see the documentation that was written at the interviews, we'll have to provide it.
Yeah, but we don't have to turn it in necessarily by Wednesday.
Well, Mr. Brodsky will need it, so it's public record. If somebody requests it, we do have to have it. Her recommendation was to turn it in a day or two before.
We can keep our own record.
Absolutely, but give him a copy of it. Just give him a copy of it. So, with that said, I think Mr. Brodsky should bring the first candidate in. Oh, wait, let me stop. I am in agreement of asking every question on here, because honestly, I think these questions cover every area of school board now.
Well, I would personally
And I agree
prefer
with
if
Mrs.
you
Stutter
would
that,
ask.
I agree with Mrs. Stutter that they have been asked in the individual questions anyway, so I would recommend we follow the rubrics, and when each individual board member asks their question, we write it down and we grade it in the same manner. Having said that,
Oh, no, I
is there any
disagree.
discussion?
I disagree on the grade in the same manner. I reserve the right to score my rubric and weight the questions differently on the ones that I think are valuable.
Do what you like.
Thank you.
You have every right to grade it however you like, honestly. Are we good to move on? All right.
So just to be clear, Madam Chair, who's going to ask the first question? Are we going to
I'll start with the first
We
question.
go 1, 2, 3.
We'll go through them.
Okay.
Just so you know, if we're going in order, I will not ask 2, 7, or 8. Those are not my
8.
questions.
All right. Let's see, you would be 1, 2, 3, 4, you'd be 5 and 10. Are you comfortable with 5 and 10?
I'm comfortable with 5 and 10, thank you.
Give them the choice of handheld or for letter.
Are we good?
We're good, thank you. Thank you, ladies.
I'm sorry, no, I'm not comfortable with 5. I was one of the ones that I,
2, 5, and 10. You said 2, 5, and 10?
so I would do, I'll do
These-
number 6.
2, 5, 7, and 8.
2, 5, 7, and 8 are the order that I'm not comfortable
You're
with.
not comfortable with 2, 5, 7, and 8.
I'll just repeat 5.
I'll ask 7, where you got?
Would you like a handheld or a withheld?
I do,
Ms. Bolo, will you switch 4 and 5?
Okay.
Ms. Gilhousen, are you comfortable with 4?
That's good.
Hey, how are you doing?
Good morning.
Folks,
Good morning.
We're going to have to have a seat right here. Jordan's going to hook you up with
Okay.
microphones and you're good to go.
Good morning, Ms. Cannon.
How are you?
We're great, thank you. And thank you for your interest in the position of school board attorney for Clay County. We appreciate the time you've committed to this process and your willingness to come and interview with us. I'm Janice Karakis. I'm the chairman of the Clay County School Board, and I'd like to take a minute and allow my fellow board members to introduce themselves.
I'm Carol Stutter, Vice Chair.
I'm Betsy Condon.
Mary Bola.
Ashley Gilhousen.
And this is our superintendent.
Good morning, Addison Davis. Nice to meet you.
We're glad you're here today. I'll just give you a little review of how this is going to go today.
Can we pause until she gets hooked up?
Sure.
Then she's not interrupted. I should say that.
So the format for today's interview will be as follows. We'll begin by asking you to give an introduction of yourself for approximately 5 minutes.
Okay.
And then we have some questions that we will go around the table, and each board member will ask a question, maybe a 3-minute response,
Okay.
till we run out of questions or time.
Okay.
At the end, you can ask us any questions if you have any, and that's the format. So if we're ready, if you're ready,
Okay.
we'll begin.
So a little bit about myself. I have been practicing law for almost 20 years now. I know, I did that too. I was the youngest to graduate from my law school class, so that's why I keep that in mind. So I am originally from Jacksonville, Florida. I have back 4 generations in this area, so my roots are here. I went to Florida State University and then University of Memphis for law school, which I found great, but I did not like the cold and the ice, so I came back to Jacksonville to be with, family and friends. I began my career at Jacksonville Area Legal Aid. I had taken an elder law workshop in law school and loved helping people, and so I thought that would be a good fit for me, and started in the area of family law. So I did a few years of litigating very difficult custody and divorce cases. After that, I moved on to corporate work. I was recruited to act as the VP for Human Resources for a large company who was the largest franchisee for Waffle House restaurants. So my experience with them was to basically consult with the executive vice presidents and manage workers' comp departments, human resources departments. I would fly to other states to do investigations for sexual harassment claims, discrimination claims, and make sure that the company was protected, try to work out employee issues as they arose. I did work with outside counsel there, so I did not do litigation with them per se. I did consulting with the attorneys who litigated for us. I did go to one mediation where we settled with some harassment suit for $500, so that was a great thing for us. I was happy to help our outside attorney with that. I, from that point, moved back to Jacksonville and was recruited again by Jacksonville Area Legal Aid. I was doing then part-time work as I had become a mother and worked on elder law issues for them. I did a lot of educational community. I would go out to the elder law communities and give information on their rights, on wills and estates, on just, we had a grant for that, so I managed the grant. I was required to, keep numbers on grants to make sure, of course, you have to be productive when you're getting money from the federal government, so we had to make sure that that we were keeping our numbers and doing what we needed to do to show them that we were being effective in those areas. From there, I moved to teaching. So I took a position at Kaiser University, and I worked as a paralegal instructor for their paralegal program. So I was required to teach courses to undergraduate students. Some of them wanted to go on to law school, some of them just wanted to be paralegals. And so, and those are small classroom sizes, so I was able to get kind of down and dirty and do really interesting projects with them because of the small classroom size. So we taught contracts, wills and estates, which I had practiced under the elder law grant, business law, everything probably that you can imagine. From there, I moved on to Florida Coastal School of Law, and I did some adjunct work there. I worked for a couple of years doing what's normally known as legal research and writing. So it's a standard course that every first-year student has to take. It's now called, at Florida Coastal, Lawyer in Process, because they included a little bit more than what we used to take. So I basically was teaching students how to read statutes, how to research case law, how to put that all together, how to read a 50-page opinion and pull out the 20 sentences that were important in those 50 pages, and then how to make an argument on a memorandum of law that you would be submitting to the court. The second portion of that class did involve mediation. So then, well, how you have your argument, you know what the ups and the downs of your case is. So now what are we going to do to resolve this? Because it is always easier to resolve a case outside of court than wait for litigation. And so coached them through how to best do that. I was certified as a family law mediator on the side, and so that was very helpful in everything that I've done since that point. After Florida Coastal, I took a position with Adams Acres, which sounds like a horse ranch, but it actually is a company that manages group homes for developmentally disabled adults. And those individuals live in a house together, and the company hires direct support professionals to go in and take care of them around the clock. So my role with them was twofold. I was hired on because the state had overspent in that Agency for Persons with Disabilities is where we were regulated. And APD, I believe, had overspent by $100 million or something the previous year. And so the director of APD had been given an ultimatum of, you get your budget under control. And so in doing that, they really just did cuts across the board with everybody in the state. Well, the agency that I worked for was extremely, our clients were extremely needy in the sense that they were called intensive behavior clients, meaning that they have a developmental disability, but many of them also had a mental health issue, so they could be bipolar or schizophrenic, and when they went to that place, it became very difficult, violent. We had the ability we had state training on how to physically intervene. So it could be that people get hurt, And so for those type of clients, it was going to be very difficult for us to take those funding cuts because we just couldn't sustain the staffing and what we needed, and also the mental health services that they needed. And so I was asked to come on to take on the role of basically fighting those cuts for the people that needed to keep the funds. But because that was not necessarily full-time work, she also wanted someone who would be able to manage employee relations. And so I served kind of twofold there with hiring, discipline, making sure that we were following regulatory guidelines for APD. We had state audits that happened monthly and annually, so I had to make sure that every piece of paper, every employee had everything that they needed and that we were up to date, and to make sure that the regs, if they were changing, were known to us and that we followed those and were in compliance. So that's what I did with Adams Acres. And do something very similar now with ECHO. It is a very similar type of organization, but we deal mostly with children who have been put in group homes because they are extremely difficult to handle. So mom and dad have said, I work, I'm not a professional, I can't keep up, So we take care of them. So with that, I have experience then now also in the school board, because we have 20-something children that are going into these public schools, and public schools are having a very difficult time managing the intensive behaviors of the clients that we serve. So I go to IEP meetings and manifestation meetings and try to resolve issues in the school board with my current position.
Very good.
Can I ask you a
Thank
quick question?
Sure.
Are those students generally put into like an EBD classroom or?
Oh, absolutely,
Okay.
yes,
Just
yes,
making-
they
just
are. And there are
curious.
different levels too,
Mhm,
so they
mhm.
have, it's very hard. I feel really, I feel for the teachers, the ESC teachers, because there are so many different needs. Each client is different, and so if you have 2 classrooms and, 17 different needs, it's hard to have an effectively run classroom when you're dealing with all of the types of issues that we see.
Thank you. And let me apologize that we started a little late this morning. It won't interfere with your time, you'll still
Okay.
have the full hour.
Sure.
So I'll start with the first question.
Okay.
So what was the most difficult case that you won, and what was the most difficult case that you lost? And if you had to do anything differently, what would you do differently?
I certainly remember the most difficult case that I lost. It haunted me for a very long time. This was early in my career. I had a woman who came to me who had, it was a custody issue, and the family was from Texas, and Dad had moved to Jacksonville, Mom had moved to Jacksonville, children were in Jacksonville, and Dad was overstepping his custody rights, trying to say, well, I'm just going to have the children, and Mom had filed something in Texas, but then everyone had moved here. Well, there is a federal statute, UCCJA, Room Child Custody Jurisdiction Act, that says if you have started a case in one state, then you may not move to another state unless all of the parties are in the new state and the old state releases jurisdiction. So I assumed that we would be changing jurisdiction because everyone was here and had been here. And then I get a challenge on jurisdiction from the father. So he had a very smart attorney who had come in on the other side and said, nope, this should be heard in Texas. Well, I thought, that's ridiculous. Everybody is here. They've been here for a year. So I did a memorandum of law and got in with Judge Nachman, and he says, yeah, well, what the statute says is that the court has to release jurisdiction for me to be able to act. So we will have a hearing, we'll get the Texas judge on the phone, and we'll sort this out. Well, the Texas judge got on the phone, and that's when I learned that don't mess with Texas. That's when I learned that you don't mess with Texas, because the Texas judge refused to relinquish jurisdiction to Florida, which I thought was ridiculous, and I think the judge on our end thought it was ridiculous to make everybody go back to Texas. And what broke my heart about that case was that the mother did not have the resources to go back. Dad did, and he knew that, and he knew Mom couldn't take off of work. And so to me, it just was a heartbreaker that justice doesn't always prevail.
Is there anything you would have done to
Maybe, I thought about it, and really the only thing that we could have done in that case was to appeal. But in my role at Legal Aid, we did not have funding to appeal. So I did send her a referral, to Texas Legal Aid, but, in my mind, I always think it worked out.
Thank you for
She
that.
got off work and she found the money, and, but, that was just one of those heartbreaking cases.
Well, thank you for your answer and your honesty, because none of us want to tell about a failure. So I appreciate that that touched your heart.
Yeah.
Mrs. Studd, you have a question too?
Before I ask that question, I want to know, did the woman keep custody of the kids?
Well, I lost touch because thereafter, she was not my case anymore, and like I said, I did make some contact with the Texas. Yeah, like I say, in my mind, it all worked out, right?
I think that was the
But
purpose.
the reality is, I don't know because, I had other cases.
I was just curious, I like the finale. Yeah, I know y'all were wondering too.
Excuse me,
Okay.
before you asked your question though, there was the first part about the difficult case you won. Did you
Oh,
do you have?
Okay.
I'm sorry, I didn't mean to.
Well, in the last couple of years, I had, with Adams Acres, we were, it was difficult in the sense that we were going up against the state agency. So, and they have a lot of backing, and we depend on the Agency for Persons with Disabilities to give us referrals, to give us clients, and to be fair with us whenever they are in audits with us. And so to take on that state agency was difficult. And what I did was sought out other attorneys that were in similar situations. So I had a friend who was the ARC counsel, and so they were getting cut like we were. I had an old coworker who did a public benefits forum at Florida Coastal who had seen the same type of thing. So we kind of band together and decided that we would do depositions of state officials as a threesome. We would all go in together. And so we were able to depose their experts and our experts. And we did have to take that to trial, and we won. So, but it was an uphill battle because the whole time you're trying to manage relations with the agency that oversees you and get what you need for your client. So that was
That's good, thank you. I think I spoke to Sarah Sullivan. And
She was,
she-
right, from the law
she
school.
referenced that, yeah.
Okay.
Yeah, she referenced that.
She's a great attorney.
Thank you. Question to Mrs. Studger?
Okay, question 2. I think you've answered the first part of this. How many years of legal experience do you have overall? I think you said 20.
Yeah, almost 20.
Yeah,
I was,
okay.
yes.
And what do you consider to be your specialties? Do you have experiences as a full-time school board attorney, and if so, for how many years? So, what are your specialties? And any experience as a school board attorney?
As a school board attorney, I do not have any experience. I certainly do have experience working in the school systems, but on the other side, from the side of the student or the parent. I think my specialties at this point would be administrative law, learning the statutes and the regs that we're required to follow in our industry, and being able to make sure that we're in compliance with that. I think, so I had a situation a year ago where the state had promulgated a new handbook. So in administrative law, they have handbooks. They're not, we do have statutes and administrative code, but then we also have handbooks, kind of how to do these things, and those are considered rules as well that we have to follow. They spent several years redrafting this Medicaid handbook, and then once that was promulgated, they work with a corporation who does the auditing, and the corporation sets out tools, and those tools are used, check yes if they've complied with this, check no if they've complied with this. So we use those to make sure that we are in compliance with what they're actually coming out to audit for. They can ask us for funds back if we're not in compliance with all of those things. So as I'm reading through this new tool, I see that they have listed, one of the regs is that to work in our industry, you have to have either a year's experience in the field or 30 college credits. And it's very difficult already to find because of what we are funded at. So the tool read a year of experience in the field and 30 college credits. and I thought it was or. So, bells are going off and I'm alerting my owners to, this is going to be impossible to staff our agency. And then I flip back to the handbook and nope, the handbook has a semicolon there. And then at the bottom of a few other things, it has or. So again, we're calling our agency that regulates us to say, I think you're wrong. And they're saying, no, we're not wrong. We've drafted it all. And so I'm pulling back and I'm highlighting statutes and regs and I'm sending the handbook versus the tool. And well, no, I think it's both. And I believe they were even already going out and auditing using that tool. Well, it turned out when it got to the highest person, that they found out, oh, this was a typo on the part of whoever it was that created the tool. But I was floored that no one else in the state had caught that distinction, which would have been devastating for us. So I think, one of my strengths is that I'm able to really go through statutes and regulations and figure out what do they mean, how to apply them, and try to figure out the differences and then be able to work around those as needed.
Very good, thank you.
What types of cases can we expect you to outsource, and what type of oversight process would you put in place for those outsourced cases?
Okay, well, this was a question I sort of had for you all. In my work so far, I manage workers' compensation claims, but I do not defend workers' compensation claims, and I would assume that would be the same for you all. Usually the work comp insurance has their own attorneys that handle those type of things, and I do manage those claims, meaning I speak with the auditor, the adjusters, and find out how's it going, what are we doing. A lot of times they'll have the employee needs to get to a specialist, and the adjuster hasn't. They take a week before they try to get in with a specialist, and I'm trying to get this person back to work. So, because after 7 days, then it turns into something different. So I try to stay on top of those folks, and then when it gets to the point of attorney, if the worker does get an attorney, then one is assigned for us through the insurance agency, and I do work closely with them to say, here's the deal, here's what's going on behind the scenes. And a lot of times it's attorneys who are disgruntled, and so I am a provider of information to that person to be able to help the defense. So that's how I manage workers' comp claims, but I don't actually negotiate or go to court, on work comp. Same thing for employment law, EEOC type of things, or Department of Labor. We've had investigation in the past for that. And I am a person who is giving the employment law expert, the person who actually litigates against the Department of Labor or what have you, giving them the information of the inside. Here's our policies, here's what happens, here's what really happened here, here's how I think you could win. So I'm giving them all of the information that they would need to be able to go in and defend. But as far as being an expert in litigating a Department of Labor claim or an employment law claim, I have not done that per se.
How do you plan to manage situations when the school board's priorities, that's the 5 of us,
Okay.
differ with Mr. Davis's? Let me repeat that. How do you plan to manage situations when our priorities differ?
Okay. Well, I'll start out by saying that I'm an optimist, but I would hope that Mr. Davis's priorities and the school board's priorities would be in line in most cases. And I always like to, get to yes, work towards yes. So I think that maybe I could be a mediator between the two if there were a time when those priorities didn't align. I know there are statutes that will say what the school board has authority over and what Mr. Davis has authority over. And so if there were no resolution and you guys just didn't see eye to eye, then I guess at the end of the day, I'm going to look at the statute and try to advise both sides on, well, you know, they get to make the choice in this situation, you know, per Florida statute, or, sorry, you have to defer to Mr. Davis. That's a hard one.
Thank you. Ms. Gilhousen, would you like to ask question 6 instead of 5?
Yes. How do you view the school board attorney's role in providing counsel to individual board members? How would you handle requests from individual school board members?
So if you came individually to me with a question about, say, school board policy,
Sure.
okay.
I guess what the question is getting at is, are we going to be privy to attorney-client privilege individually?
Okay, I also had that question, because I know there is a sunshine law, and I wondered whether I would be considered one of the board, and if the two of us were meeting, let's say, would it need to be in the sunshine? And I'm not sure on that answer. I certainly could find that out, but I had wondered that before, because I would like to, of course, have relationships with each of you, but I do need to find out what is required, and I would say my initial response would be that if you came to me about a question, then I would want to make sure that all of the others also knew the response to that question. So maybe an email out to, hi, this is, Ms. Gilhousen brought this issue to my attention, and here's what I told her, or here's what the statute says. But I think then at that point it becomes public records information, and so that's tricky. I did read, so I tried to do a little bit of research. I did read something that said that there are exceptions and that there would be attorney-client privilege if I were speaking about, say, like litigation, that then attorney-client privilege would hold, but I'm not so sure that it would hold with just you and I speaking. But again, I haven't done enough research to know. But I certainly would want to make sure that if need be, that everybody was in the loop as to what one person had asked.
Can I add something to your question? I see the word counsel here, and I would, if the board was having a specific discussion, or the chairman handled a motion or something incorrectly, but it wasn't egregious enough to stop the meeting, would you be comfortable after the fact talking to one of us and saying, just so you're not stepping in potholes next time,
Yes.
this is what I would recommend?
Yes, absolutely. Yes.
Thank you. So I'm going to do the next question. How do you ensure that you remain the school board's attorney and not part of the district team? How would you remain objective when dealing with legal issues? And you're probably not, I'll clarify what I mean by that. If we had a situation where we had a problem with an employee and the board was discussing something, and we wanted you to research and come up with something that, according to the statute or law, you felt wasn't correct, would you go along with the majority of the board if, let's say 3 of us wanted you to do something that you felt wasn't the right thing? Would you go along with the board, or would you really stick as our legal expert? And that's really what we're looking to find.
Right. I would absolutely inform you as to what the law was, and I would give my opinion as to what could happen if you didn't follow it. But in the end, I know that you all are, you have the power to make decisions on your own. I'm an advisor, And I do always, I think it's very important to always educate my clients on what the law says, and then what case law or what interpretation of statutes have been put out there, because there is always like a dissenting opinion, another way to argue. There may be facts that are different in this case than have been used in the past. So I like to give my clients both sides of the situation. And then I know ultimately it is up to you, but I like to make sure that you're informed. I had my old boss would sometimes take my advice and sometimes would not take my advice. So there was a situation where she had listed in a policy, you will not be paid for any overtime work that you do that was not previously authorized. And I get sure, right, that's a nice policy to have, but the Department of Labor requires you to pay employees for every hour that they work, every minute that they work. And so I had advised her, I don't think that we need to say this. I think that we need to say that disciplinary action can arise if you, use overtime if that has not been approved. She can't say you're not going to pay them for it. And in the end, it was her company, and she decided to do, something different. And so I felt like I had advised her on, on what the law was, but if she wanted to make a different choice, then that was her right to do so. She owned the company.
Thank you. Thank you very much.
Number 7. As a school board, we deal with a wide range of legal issues unique to education law. I'm going to go through a list of issues you can expect to face if hired. How many cases have you previously handled relating to ESE students and the development of IEPs? I'll just go through it one at a time because there's a list here.
Okay. So I have been in numerous IEP meetings. So we have at my company, we currently have 20 plus children that are in the public school system, and many times those children are doing just fine, and many times they are very difficult for the teacher, for the school. And so in those cases, I do have to go to the IEP meetings to make sure that they are getting what they need. What I find in most of those cases is that sometimes I do have to fight to get what the person needs in the IEP. And normally I do get it in the IEP, but what I find most of the times is that the IEP will be written to the extent that the student needs. Okay, maybe that's a one-to-one supervision, maybe that's just transition assistance. We deal with a lot of autistic children, and so maybe PE is not going to happen for that child because it's overstimulating, it's too loud, there's too many people, there's not enough supervision. So maybe we talk to mom and the student to say, let's try art. That seems to calm him down. That's, something where he can excel. He loves to draw at home. So we try to work around to do the type of things that's best for the child. But many times what I find that I'm advocating for is the ability of those paras and the teachers in the actual classroom to be able to follow the IEP. So most of our students have behavior plans, and behavior analysis is a very difficult topic, and it is very almost counterintuitive to what many people may do. So if a child is he is attention seeking, and most persons would say, stop that, stop beating on the desk. And what they don't know is that that is a reinforcer, that is attention. Even though it's negative attention, it is attention. And so the behavior plan would probably say, ignore that. But a para who's, making who knows what per hour is not going to be educated on how to deal with some of those behaviors. So my role a lot of times is to try to make sure that the behavior specialist or the behavior analyst in the school is filtering down that information to those peers, because it will make it so much easier for that classroom teacher to be able to teach the entire class. So that's my role so far in IEP meetings.
Let me try to get through this, because we've got a whole bunch of them.
Okay.
How many cases have you previously handled relating to issues pertaining to student due process?
Okay, I have not handled a due process claim. I do try to work very hard not to file due process. I did have one case where we called in for some help from Disability Rights. They're an organization in Daytona, and they stood up in the middle of the meeting. I guess we're just going to file for due process, and I tried to calm down, because in the end, I have to work with those educational folks. And so for me, it has really been about not going there. So I do not have experience there. Of course, I do know how to file it and the process that, that would go on from that point, but I've not done that yet.
Okay, thank you. And bringing or defending against Section 1983 civil rights actions?
No experience doing
Okay.
that.
Student discipline issues?
Oh, manifestation meetings, I've been in many of those where we're trying to determine whether the behavior that was, that they disciplined for was a result of the person's disability. And so, yes, I've handled at least 10 or more of those.
Okay, and the McKinney-Vento Act for unaccompanied children?
No, ma'am, no
Okay.
experience.
Educational accommodations related to disabilities or other special needs?
Yes, sure.
That's right.
Yeah.
I
Yes,
can
yes.
answer that one for you. Issues related to FERPA, the Federal Education Rights Privacy Act?
No, ma'am.
Okay. All right. That's it, that's it, the
Okay.
list, I guess, huh?
How would you expect to interface with other state and local government agencies as in your role as school board attorney?
State and local government agencies, like Department of Education or local folks. So I can speak to my role now. Every once in a while, we have to deal with Department of Children and Families. Somebody's made a call and we have to deal with them. So the company's idea is always to be friendly, to get them what they want, because we know that good relationships outside of what's happening, at the moment are a foundation. And if they know that we are professionals and approachable, then they're going to be more easily relatable whenever we do have to deal with them. Same thing for law enforcement. The sheriff's office, we have a couple of folks who know us, and we try to keep relationships with them. We do have situations where we're taking our clients out, say to Walmart, and the client starts having a behavioral episode, and we do have to be physically hands-on, which is normally not allowed with healthcare, but it is in our industry. We've had somebody call, oh my gosh, they call 911. Somebody's putting their hands over this disabled child, and and so we have to be able to, the officers know, yes, it's Echo, they're okay, they're the good people. So I do understand that it is necessary to have a relationship with others in the community, just to make sure that they know where we're coming from, and that, it's nice to be able to get information from people that you make relationships with.
Thank you.
Number 9. And I'm sorry, I smile a lot because I'm a teacher, or have been a teacher up until November, and can relate to a lot of what you're talking
Yeah,
about with
it's
takedowns and things of that nature.
Very
so-
difficult, yes.
And then explaining it to other children as well.
Right.
Number 9, I apologize. What types of cases have you routinely handled for school districts in the past? And it may not necessarily be just for school districts, but with school districts in the past.
Okay. Cases where I went to court, I have not had any cases where I was litigating for a school board or against a school board. I did have, I was sought out a few years ago. I had a friend of my previous owner's company who did something similar to what we did with juveniles, and the juvenile's mother was suing the school board for intentional infliction of emotional distress or something like that. You know, you all had ruined his life, and Morgan was there to save the day, and I was asked by the therapist of the child, because there was a subpoena for the child's psychological records and case notes, and the therapist was saying to me, I don't want to turn over these case notes, because in these case notes is a lot of information about his mother that was going to be explosive in the child-mom relationship. And so I thought that was a really interesting issue as to whether a minor child could step up and say, I don't want these records released because Mom and I are trying to work on getting, you know, our relationship back. So I did go in and file an objection and a motion for protective order, and was able to convince the judge that those records should not be disclosed. So that dealt with the school board, but wasn't really on either side.
Ms. Gunhausen, you are the question 10.
What do you think makes you the most qualified to be the Clay County School Board Attorney?
Okay, well, I have a broad range of experience in many different areas. I am easy to work with. I'm a great writer. If I don't have the answer to something, I know where to find it. So I have attorney friends that, you know, it's nothing for me to pick up the phone and call my guy who's an insurance defense person and go, hey, what do you think about this? You know, or my Harold and Harold friend and say, yeah, would you guys take something like this? You know, or, you know, to be able to figure out what we need as a best solution. I am well versed in interpreting statutes. Like I said, I taught legal students how to read statutes and find out how the statutes have been interpreted in case law thereafter. So I feel like I'm good in that area. So I think that I have many of the, of course, the education experience as well. So many of the qualities for an effective advocate for you all.
That's a great answer. Thank you. I'm okay right now, so if anybody has further questions, Mrs. Sutter, do you have an additional question?
I'm just sitting here thinking, what do I ask? We have some open questions now that we just bring up, something that comes up. Would you explain to us, in your opinion, and from what your knowledge, the role of a school board member and the role of a superintendent?
To my knowledge, a school board member, or I guess you as a board, are responsible for, I know for speaking on behalf of your constituents, making sure that the programs in place are effective, making sure that the teachers are like I said, I've done a lot of reading here, and I'm getting confused now. I know that you all are able to, I guess, direct, as far, I'm thinking about raises and such, like, you all are able to make decisions on that type of thing, to make sure that the, I guess, program implementation for different types of things that Clay County may want to offer are put up for vote. I believe the superintendent is more concerned with policy and making sure administratively that the different departments are doing what is required. I know you all handle transportation, you handle funding, you handle programs. But again, there is a lot of information there. Like I said, I'm not well versed on how the roles come down and how they're separated out yet. But I know there are statutes on all of those things, and I would be able to figure out which roles are for each.
Thank
Yes.
you very much.
It's been no secret that we've been in tight financial times over the past probably 5 or 6 years. We're coming out of that. But my question is, what additional resources would you expect to be provided for you, our
Resources for what I would need for my position. This was one of the questions that I had for you as to whether do I have an assistant? That is always helpful for me. But really, I think the resources that I would want would be just to make sure that you have, and I'm assuming you will have contracted, say, employment law attorneys and workers' comp attorneys, and okay. So if I have those persons to be able to reach out to, I do that every once in a while because I'm as smart as I like to think that I am. I do not know everything. It's like a doctor, you have a specialty. So I do like to reach out to the folks who are experts in the field, and I do usually save that for when I have done all of the research that I can do, and I still really don't understand, procedurally, realistically, what's going to happen in this situation. So I do like to pick up the phone on those occasions and ask the experts that I know. And if you have those folks on retainer or something, then I would use those. Like I said, I do have personal resources as well, though. So those are the two things that I would think of up front would be an assistant if it's in the budget, and then folks that I might be able to call if I have issues that I wasn't sure of.
By assistant, do you mean paralegal or
No,
just
just,
secretary?
right.
Legal secretaries.
That's a good question.
I
Ms. Fuller?
have a quick question. You taught contracts at Kaiser University,
Yes.
and we get involved with a lot of contracts.
Okay.
And there are contracts that we enter, and there are contracts that we sometimes want to get out of.
Mhm.
What sort of experience have you had in developing contracts or I'll just use my own words, getting out of contracts?
I'm trying to think of a few contracts that I have drafted. I was a business owner for a while, and so there were a few contracts that we had with vendors and such and usually they have their own contract, and what I like to do is if they provide me with a contract, I just read it through, and the portions that I don't like, I'll just scratch through. And most of the time, for folks who are maybe less educated in the field than I am, they don't ever notice that I've scratched through, or they say, oh, okay. Every once in a while, you get some pushback, and they'll say, sorry, this is part of the contract. And then I would, go to you guys to say is, here's what this provision is going to mean. Are you okay with it? And we could always negotiate, but just as long as you all understand what each provision means. As far as getting out of contract, there's always a way to get out of contract.
Did you repeat that?
There's always a way, I think, to get out of a contract.
That's what I thought.
Yeah.
It might be expensive.
It might be expensive.
Yes, it may be expensive. I was going to say, it might be that you're paying to get out of a contract, but many times, the payout up front is so much better than having to continue on with the person, especially if it's a hostile person on the other side. You don't want to continue that relationship, and so if you can't find something defective within the contract, then sometimes I'd recommend just to pay a little bit of it to get out.
That's a good question.
Mhm.
Thank you. Ms. Gilhousen?
I think we've covered quite a bit, so I'm just going to pick out one more. How does your educational background and work experience uniquely qualify you to represent the school board of Clay County?
Well, I think I answered that in the last one. I have, like I said, experience with not only reviewing regulations, but also teaching how to read them and how to write for or against them. I have the experience in I think what uniquely qualifies me is my in-depth knowledge of the ESC student population. And so I don't know how many IEP meetings I would be expected to be involved with, but certainly I am well versed in being able to recognize issues there and come up with solutions, which I think that's always what I try to do, is to come up with solutions. And like I said, I do not like litigation. I think it's a waste of time and it's a waste of money. Of course, I will litigate if I have to, but I really would prefer to try to figure out from both sides of the aisle what are the issues and how to resolve them within the budget that the school would have, of course, but then also to make the parents happy.
I have one more question. Do you know if the school board falls under the Administrative Procedures Act?
I would assume so.
But you don't.
I do not know.
Thank you.
I have a question, but can I write that one
Yeah, I'm
first?
writing too.
Administrative Procedures Act.
I forgot about that one. And Ms. Khan, whenever you're ready.
How do you view the school board attorney role in providing counsel to individual employees? There was a question earlier about providing, excuse me, about your role as far as the school board and superintendent, but what about individual employees within the district?
Again, I would have to look to statute and look to you all. I think that becomes very touchy because at the end of the day, my client is you. And if the employee is, I guess it would depend on the situation. If the employee is seeking some type of legal advice regarding is the school board trying to get over on me, or are my rights being violated in some way, or what have you, then of course I would not be able to counsel them on something like that because I am defending you all, and so that would be a conflict. But if it were a certain school board and member or a teacher, you mean like a teacher of some sort?
Yes.
Then if you were interested in protecting or shielding that employee and me being able to talk to them about rights or prep them for, say, outside, if somebody is suing the school board because of something a teacher did, let's say, then in that case, I would, like I said, I'd need to defer to statutes and to you all as to whether or not that would be proper for me. But if it were proper, then I would be willing certainly to make sure that the employee was up to date and educated on the types of things that we would want them to know, what to say, what not to say, and those kind of things. But I don't know. I'd have to look at that as to whether or not that would be an acceptable role. I know, like in my role right now is legal resources, or legal affairs director and human resources. And so sometimes that gets a little murky because I play to our employees as I'm your friend. Whenever things go awry, please come to me and we want to work them out. But in the back of my mind, I know my allegiance is to the company. So I'm never going to get roped into that situation where I am disclosing or giving advice. It's just something that might come and backfire onto the company.
I have one more question. I just became familiar with this, so forgive me if I don't say this properly.
Okay.
Are you familiar with the Martindale Hubble Law Directory?
Yes.
Are you rated in it?
No.
Thank you. I just became
I don't,
familiar with
I would assume not, no.
it. Okay.
I worked in litigation for so few years, and then I kind of went out to corporate that, it was
Like I said, it's
never,
10 years ago.
yes, never really came up in my practice.
Ms. Gilhousen?
I'm finished.
Okay, fine, too. Is there any other questions from board members? All right, would you like to just take a few minutes and ask us any questions?
One question that I had was regarding hiring, as far as, would I be under contract, or would I be just a regular employee that would,
It would be a contract. Mr. Brodsky, would
That's
you like
correct.
to discuss
It would be
that?
a contract, and the amount of the salary between 120 and 150,
okay,
depending on experience, and that would be negotiated with the board. So you would be under a contract.
okay. And is it for a one-year term, a two-year term, or how does that work?
That's at the discretion of the board.
And we haven't actually discussed that yet. We will probably discuss it at our February 2nd meeting, where we
We
will
could tell you
discuss
about
or.
precedents, though. I mean, how we've handled it in the past, we could discuss that with her.
Yes, and traditionally it's been, Mrs. Sutter, how long's it been on there? 2 year, 3 year contracts?
I think it was a two-year, I think
Last time was two,
it
wasn't
was a two-year contract for last
Okay.
year.
Yeah,
That's
probably.
right.
That's something we haven't ironed out.
Our
Okay.
current attorney is on a month-to-month basis, if you can believe that.
Wow.
Well,
Okay,
it was to be temporary. yeah.
okay,
So that's probably what it would be. You know, we will all discuss it.
okay.
Probably a
Great.
2-year.
So there's a wide range.
Thank you so much for coming in
We
today.
appreciate so
We
much
know
your
we-
time.
We tried to be kind.
Well, if you have no further questions of us, then we'd just like to say thank you for your time, and for the information you provided, and be willing to come and meet with us today. We will meet on February 2nd, and that's when we'll discuss and possibly take some action on it.
Okay.
And so we'll have Mr. Brodsky contact you right after that.
Okay.
So, well, thank you so much.
Thank
Again,
you.
I
You're all doing
apologize if we're
great.
late.
Thank you.
Thank you.
We have a,
Take a
That's you.
few minutes.
Stan, thank you for considering Clay County.
Thank you so
Appreciate it.
much.
Thank you so very much.
Such a pleasure to meet you.
Ms. Bush, I paused my recording.
Good.
It was a great meeting.
I
I really enjoyed your slides, sorry. But as I said, as a teacher, it was
yeah,
nice meeting you.
thank you for coming in.
Thank you for coming. Again, apologize if we were delayed.
No problem.
Very nice to meet you. Thank you.
There's still been a discussion.
With their kids.
With their kids, and she had a degree, and it was explained to me by Andrea that you want to make sure that you don't have someone who's just agreeing with you because 3 board members say, you know, let's say 3 of us want something so red and just say, okay. You want someone who's going to make sure that you're not stepping in trouble, so they're going to encourage you to follow the legal regs, the legal law, and the right procedures. So I probably didn't ask it correctly.
Yeah, I don't like the wording there.
Yeah.
It makes it sound like you don't represent the district, you represent
Right,
us.
because you do, you are part of the team, yeah. But like she said, you want to make sure that
I
they
think
are.
just ask that second part. Just how would you present objectives when dealing with legal issues? I think that's a better.
Always just, you know, following the,
So we're setting the expectation, you know, in the interview process, and I don't want them to come in with a preconceived idea that they can't work with our team.
are you okay asking 6 each time?
Yeah, that's
So just say 6 and then I'll go to You guys have any questions that, like I do? And that's what should be fresh in my mind. It's hard to go. You had good questions
I
there,
started-
though.
It was
Please,
all for-
please ask the same ones
Okay.
again.
Two. Because when I'm asking, do we have a specific, because I knew the answer before I was
Thank you for the water.
Thank you, Mr. Roski.
You're welcome.
We're ready when you are, Mr. Roski.
All right, awesome.
Was this the?
Probably from your office. Did you need? Who was saying?
Sorry.
I don't know, it might be.
Wired up.
Hello, everyone.
Hello, how are you
Good.
today? Thank you for your patience.
Thank you. You want to know what I was just telling Mr. Brodsky, and look, we even had water. I haven't had a moment of solitude like that in a long time, hanging out under an oak tree.
Well, we hope you enjoyed it. Good morning.
Welcome to Clay County.
We'll let you plug in before we begin.
Okay, the mic is coming off.
Yeah, Jordan.
Let me just put it on the top. How's that? Testing.
All right, good morning, Mr.
Good
Fowler.
morning.
And thank you for taking an interest in the position of our school board attorney for Clay County. We appreciate the time you've committed to this process and your willingness to come for an interview today. I'm Janice Karakis, I'm chairman of the Clay County School Board, and I'd like to take a minute and allow my fellow board members to introduce themselves.
I'm Carol Studdard.
I'm Betsy Condon.
Mary Bola.
Ashley Gilhousen.
And this is our superintendent.
Good morning, sir. I guess you again.
That him the best.
All right, thank you. So I'll just give you a brief how our format will go this morning. We'll start by giving you the opportunity to introduce yourself to us, and then we'll proceed into a list of questions that we have, and to have maybe 5 minutes to introduce yourself, and then a 3-minute response to all our questions. And at the end, we'll give you the opportunity to ask us some questions.
Sure.
So if you're ready, we'll begin.
Well, I'm David Daggett, in case you were wondering how that's pronounced.
I apologize, I got it wrong.
My brother's taken it a long way to clarify that. He's a CBS correspondent, and Pelly had gotten his name wrong many times. So that has really helped me. Of course, I'm much more articulate and handsome than he. So I have, as you'll see, the resume that I provided to you is what I'll call my short form resume. And I brought in what I call a sample of representative experience that I'll distribute. I'll be happy to distribute now or after we're done talking. And it will show you the depth of my experience and commitment to school law. You may note that I have a PhD in education administration. I was in education before I went into law, and in fact, it was the PhD which brought me into law because I did a study where essentially I was with the school board attorney for Palm Beach County, observing what went on, and the big takeaway was it struck me the influence and the importance of a school board attorney to public servants on a school board. In law school, I completed my PhD. I'm still hearing it from my wife with the tuition. So I completed the PhD and worked, which you're not going to see this on the short form resume, worked at the Miami-Dade County School Board Attorney's Office and actually got paid, which was nice, while I was in law school. And I wrote law review articles and scholarship, presented nationally for the Education Law Association. Throughout my tenure thereafter, I went from law school and took on a federal clerkship where you're essentially working to give guidance to a federal judge. And that was in Ocala, where I worked with a very well-known jurist, Judge Hodges, and a magistrate judge who's now in Gainesville. The guy that I co-clerked with is now the judge out in Ocala. But anyway, you're not going to see in the short form resume that during that whole time, even as a clerk, I continued to write. in education law. I was published again in a law review article, and I presented it. One of my presentations dealt with Brown, like a retrospective look at Brown v. Board of Education. And I became kind of interested in that, not only because it was the 50th anniversary of the decision, but we had things coming before the federal court that considered the exclusive effects of alternative education programs. I went from the clerkship into private practice. And although you're not going to see on my short form resume, I continued to present and write scholarship in the area of education law. And I was attempting to generate private work, but it was at a law firm called Steele, Hecker & Davis, which, and this will be funny later, 2 weeks after I joined it, it was essentially taken over by a very, very large, very good law firm, an international law firm by the name of Squire Patton Boggs. So I went from that situation, and a friend of mine, the guy who's now a judge at Ocala, he had been working in this place called the General Counsel's Office in Jacksonville, and told me all about it. And he really urged me to come up. So after I did come up, and I ended up joining the office, I thanked him for bringing me and my family to the murder capital of Florida. Thank you very much. But I had interviewed with then General Counsel Rick Mullaney, and just like you, it is a public agency that is dependent on basically the fiscal year. So they wanted to hire me, but there would be a delay. I wanted to come up. So a law firm, a spin-off from, I'll call it a boutique law firm with two partners from a very prestigious firm, opened up their own, and somehow they got my resume. I told them what my intentions were, and they said, well, why don't you work with us for the time being? I did, and I loved it. Two very, very good, reliable, and very reputable attorneys. And then from there, I did go on to the General Counsel's office. And I hope I'm not going over my 5 minutes, but it's worth explanation. To me, if you look at my resume, there is a distracting curiosity as far as I'm concerned. And that is, what happened to this guy in 2016? Let me tell you what happened. In October of 2015, my wife and I thought seriously about going back down to South Florida where her family is because of an aging parent and another one who was deteriorating due to the work that goes into helping and supporting a loved one. My wife, I get a little bit teary, my wife is a nurse practitioner. She has family down in North Palm Beach. We decided, let's go back there. Okay, we'll go back. So we made plans. I reluctantly told the new general counsel, a good friend of mine, Jason Gabriel, very, very good general counsel, of what I plan to do. Okay. So I resigned in June and had a great position that I'm currently in Martin County, for the Martin County Attorney's Office. I was doing a bunch of stuff that I was doing in the General Counsel's Office for the city, only on a much smaller level. We're talking about a 40-attorney office that serves everyone in a government versus a 5-attorney office that represents just the Board of Commissioners. But it was good, it was very interesting, and obviously it was in a great place. We would be very close to my wife's father and mother. Well, he passed away. And, whew. And promptly thereafter, I had taken a job, taken a position, accepted it. And there was a federal judge in Orlando by the name of Roy Dalton. He was practitioner here and in Orlando. He actually served as a federal judge here for a while. And talk about caregiving pressures. His lifelong clerk, it's a career law clerk, had to take care of her father. It was like a parallel universe and had to be out for 90 days. I told Martin County and I said, yeah, I was asked because I know a couple of judges here and they called me while I was on vacation and said, could you help out? And I told them I would be honored to help. I hope I can. Let me reach out, and things coordinated such that I worked those 90 days, and it was fantastic. So then I went to the county attorney's office, and I had delayed my entry there for the 90-day clerkship. And it wasn't a couple of weeks afterwards that the county attorney, the guy who hired me, resigned. So there was turmoil. There were obviously, you know, it kind of underscores one's delusion that you are in control of your own life. God is in control of my life, and sometimes you just got to let go. So although that was the place that we were headed, things have changed dramatically. We were very reluctant to leave here. We live in St. Johns County. We have 3 kids, 11, almost 10. 2 girls there and an 8-year-old boy. And this is the only home that they've ever known, really. We've lived for 10 years in St. John's. And I happen to be closer to this school board than I was to the city of Jacksonville. I should tell you in the interim, talk about not being in control of everything. I was blessed with the opportunity of interviewing for a federal judgeship, which, you know, that meant that attorneys needed to select me and offer me to the qualifications committee. Was I going to say no? I interviewed, but that the federal judges made a wiser selection. And I also was a finalist for Clay County Attorney. And they too went with a wiser option, and Courtney Grimm, who's a fantastic attorney. So that's, I wanted to kind of knock out that area of curiosity and welcome you to call whoever to satisfy yourself with the veracity of that explanation. Anyway, so that is it. We're really committed to being here. We still have not put the house up on the market. We're having the kids complete the school year, which is a big drag for me because I'm driving home 225 miles every weekend. I am very interested in this position, and I know I'm very excited and passionate about this particular position because I know that you're on the precipice of really, really marked improvement. I know it. And I know that there was once tranquility, and there will be again. Okay? I do believe, mind you, I've studied the role of a school board attorney, and I've been, and just so you know, in the general counsel's office. That is the school board attorney's office. Okay? You are the legal services for every agency and public official, constitutional official in the government. It was only up until recently that we housed with the Duval County School Board a legal office, which Kara Chastain is now the chief of, where she was once physically occupying the general counsel's office. But anyway, I have witnessed how very important, what role a school board attorney can have in achieving functionality, achieving tranquility, being ferociously neutral, not being influenced by personality or politics. That is something that takes effort. You've got to, as an attorney, put incredible effort into that. And I have, and throughout my career, I've done a lot of work for the school board and for board members in lawsuits, administrative proceedings. And that's why I wanted to give this handout to you, and I'll provide it to you at the end. And I really urge you to take a look at it, because it demonstrates that I'm not all talk. I have been the litigator, the guy who represents board members and the school board as a whole in litigation and in administrative proceedings.
Very
Sorry.
good, thank you.
Yeah.
And we'd be happy to have that.
Sure.
Mr. Brodsky, if you give it to us at the end, or if you'd like it now. We can look at it.
We can apologize for that, that was long-winded.
No, you're fine. We appreciate your explanation, so thank you. I'll start with the first question. What was the most difficult case that you won? What was the most difficult case that you lost? And what would you do differently?
Well, as one of my writing samples, I provided to you a Florida Supreme Court brief in the matter of Rona Silver. That was, you really have to study that case, both a win and a loss. Okay. Rona Silver was a dedicated teacher who was charged with child abuse of some of the most fragile kids that a public school district can serve, who cannot speak. So she had been charged with criminal allegations, and she was being terminated. She was represented by a fantastic lawyer, Bill Shepard, very well-known, excellent lawyer. I love him. He looks a lot different now than he did back then. But anyway, and I was working with a giant too, in a guy named Ernst Mueller, who worked with our office. And the way this played out is, and with any child abuse issue such as this, they waived the right to a speedy trial. They went forward with an administrative hearing. The administrative hearing is based on a much lower standard of proof. We're not doing a criminal proceeding. And she won in part, okay? There was then a dismissal of criminal charges. Bill Shepard pushed in every tribunal to recover attorney's fees. And there were a lot. There was a lot of attorney's fees. Under 1012 of the Education Code, there is a statutory right to attorney's fees when you successfully defend criminal or civil charges. These were neither criminal or civil charges that we dealt with. And essentially, Bill argued in circuit court, the state court, and in appellate court, state court, and in the Florida Supreme Court, and in the administrative proceeding, various sources of attorney's fees. Now, I'm happy to say that we won in every one of them, okay? It's very important to me, and that brief tells you why. I, and the school board, of course, felt it very important that we don't create a precedent whereby if someone is charged with criminal charges and you happen to terminate them, and for some reason, or discipline them, and for some reason their discipline is reversed or lightened, that you're then responsible for attorney's fees. As I pointed out in the brief, That equates to tens of millions of dollars statewide. Tens of millions of dollars taken from public schools every year. That's science. So the big picture is that the school board ultimately, you talk about a loss, the school board ultimately decided to exercise discretion. I argued and urged the board to consider the ramifications. It did. It was an excellent board chaired by an excellent attorney at the time. And they made their decision. The board had discretion to pay. But we had won in every court proceeding. So at least, you know, the court proceedings were a good thing. And essentially what happened from the court's perspective, and I say courts plural, is that the First District Court of Appeals said, if it can be shown whatever work that Bill Shepard did that was helpful in the dismissal of criminal charges, well then that comes under this 1012 statute. There's a statutory right. They didn't say, oh, there's a statutory right. They just kicked it back to the board. And in every court proceeding, the court said no. And an administrative law judge said no. So that was both the loss and the victory. That was very impactful. It was a 9-day DOA proceeding, which was the longest proceeding that they had.
Was there anything that you would do differently?
Reduced discovery. And that is something of a challenge for, I think, lots of attorneys, is to try your best to reduce expenditures on things that simply don't matter.
Well, thank you, and it's an impressive case that you went before the Florida Supreme Court.
Thank you. Thank you.
Before I ask my question, I want a clarification, since I have clarified. Did I hear you say that the school board did wind up paying even against your advice?
Well, look, the board had my advice, okay?
That's what I'm saying, you
So-
gave them advice, but they chose to do something else
Well,
because
the
the chairman
advice-
was an attorney him
Yeah.
or herself?
Yeah, the advice was such that while the board clearly had discretion, it wasn't unauthorized, but I urged of the potential harmful impact it would have statewide.
Okay. I just wanted to put the dot at the end of the sentence.
I'm glad.
It sounded like there were two parts to it,
Yeah.
and that what the district did would then affect the criminal charges, correct?
Well, that's what the First District Court of Appeals said, if it did.
Right.
If it can be proven that it did, well, then there's an entitlement. So that was never decided. And, you know, that would have been a source of litigation. You know, has it or has it not? Can you imagine a school board taking the depositions of state attorneys?
Right.
So it was, you know, mine is not the role of passing on the wisdom. Mine is the role of providing legal guidance. Here are your alternative paths. And the board made its decision.
Okay, thank you.
Yep.
Now for question 2. How many years of legal experience do you have overall, and what do you consider to be your specialties? Do you have experience as a full-time school board attorney, and if so, for how many years?
Okay, so 14 years of experience. School board full-time work was really over the course of my work at the General Counsel's office for a stretch of 8 years.
And what do you consider to be your specialties?
Well, I think that education law is my specialty, and that's a little bit of a misnomer, isn't it? Because education law is a very, very broad area of study. But I do believe that it is my specialty. I've written on it. I've presented nationally on it.
Okay, thank you.
What types of cases can we expect you to outsource? And if so, what type of oversight process would you put in place for these outsourced cases?
Well, that would require my study of what's gone on to date. and what it is your risk benefits or risk management scheme covers. In certain agencies and boards, risk management and insurance policies cover lots of things, and sometimes they cover a narrow array of items. So that has to be figured out, okay? It's a no-brainer where you have insurance coverage. All you have to do is put the demand on the insurer. You've got a duty to defend, and as far as I'm concerned, once that is triggered, the agency attorney ought not waste time and resources on something that another attorney is getting paid money to do and has independent duties to do. It just is, it saps away resources that you've already paid for in insurance coverage. Mine has always been I am more disposed, especially with a growing agency, to take things in-house. But I don't know, the financial construct and the will of a board to build an internal legal office or not. I don't pass judgment one way or another. I'm capable of handling lots of things, but my job would be to this board. That's my number one job, and where I see that it is going to put the board or the district at risk, it is necessary to obtain outside counsel. And when I obtain outside counsel, which I've done for many years, in fact, that's how I got to know Courtney Grimm. She was one of the attorneys at a firm that I encouraged that the agencies, certain agencies, hire. I take a very, very active role. I don't just check in and ask for them to report. I have points of view and experience on what works and what doesn't in litigation.
All right.
Question number 4. How do you plan to manage situations when the school board's priorities differ from the superintendent's priorities?
Well, again, and I really do admire this man. I remember working with him, his good work at the Duval County School Board. Again, I'm going to go back to the fact, because it's a fact, that the school board attorney is the school board attorney. Okay? This is not to say that a board attorney should take measures to avoid divergence and certainly divisiveness. And I don't see that happening. I see that there's going to be a movement toward convergence, okay, and cohesion. But I think that that is a necessary, just like it takes effort to remain, as I say, ferociously neutral. Kind of an oxymoron, isn't it? But it's meaningful. Ferociously neutral. You have to put effort. You have to be cognizant as the attorney, school board attorney, that you're not entirely divorced, are you, from the superintendent. He's just as much, the superintendent is just as much a member of this thing we call the school district as is a teacher, okay? Principals. I've attended, and you'll see here, which you didn't see in my short form resume, I've attended, I don't even know how many IEPs to achieve essentially conflict resolution. You've got to balance things. So it is something, just as a school district grows, so do the workloads and the nature of the work that is committed to a school board attorney.
How do you view the school board attorney's role in providing counsel to individual board members? How would you handle requests from individual school board members?
So, this is not unknown territory. In fact, it's very common territory, and it is a human thing. Okay? I've studied the issues, and I know the boundaries. Okay? The long and short of it is this: every one of you is entitled to my advice, and where you ask for it, you're entitled to my opinions. While the board is my client, and that is just a general, that is the driver. The board is my client. That doesn't mean that I cannot caucus with individuals and answer individual questions and follow their will where it is not outside of sunshine requirements and tradition to maintain privacy. You ought, if we don't have that, that's what the whole concept of attorney-client privilege is. It's got to be a safe place to talk. It is incumbent upon a school board attorney to do it. I've done it in the past. I did it quite recently. My most recent was issues, talk about board and superintendent, who has authority to do X, Y, Z, different opinions by various board members, and the latest issue dealt with school attendance boundaries and when they can change and who gets to change it, so on and so forth. There were different questions by different folks, and the good news here is that we achieved tranquility. Okay? So I've done it before, not just with a school board, but with lots of different boards for the various agencies. Like, for instance, Jack's board has its own board. JEA has its own board. I've worked with many of them, okay, and it's the same construct. It is the same construct.
Great answer.
Thank you. How do you ensure that you remain the school board's attorney and not part of the district team? How would you remain objective with dealing with legal issues? And it's kind of an odd question. So how would you remain objective when you're dealing with legal issues?
Well, that comes down to ferocious neutrality. Okay. Just as a board member is entitled to my advice if they ask for it, and entitled to my time individually, so too is the superintendent. The superintendent is charged with, boots on the ground, operations, giving recommendations to you. Absolutely, he's entitled, he or she is entitled to the advice of the school board attorney. There are many things. All it takes is, again, ferocious neutrality. The school board attorney, it has to take efforts. And I've thread this needle, and I know how to do it. Diverging opinions, you may start out with diverging opinions and maybe perceived hostility. But after counseling, and if and when asked for advice when it gets to the next level, minds and opinions may change. Okay. I hope that answers your question. I don't mean to be ambiguous about it.
Well, if three of the board members felt really strongly about something and you weren't in agreement with it, how would you handle that?
It is not my place to judge the wisdom of something. Okay? If and when an individual board member, a superintendent, a principal, the board asks of my opinion, of course I will provide it to you. Okay? But I'm very comfortable. The whole essence of a sunshine body, that is this board, is to grapple with disagreement. There's a reason that there is an odd number. There's going to be basic disagreement. And mine is not the role. That's the easy part of being a school board. I don't have to make the tough decisions. Those decisions where there is hostility among constituents, perhaps. Will I feel the repercussions as much as a board will? Probably. But that's fine, I take it on the chin.
Thank you.
Okay, that gave me a long question. As a school board, we deal with a wide range of legal issues unique to education law. I'm going to go through a list of issues you can expect to face if hired. How many cases have you previously handled relating to, and I'm going to list a whole bunch of things here.
Yep.
ESE students and the development of IEPs. Do you want me to read the whole list to you up front?
Sure.
Okay. Issues pertaining to student due process, bringing or defending against Section 1983 civil rights actions, student discipline issues. The next is the McKinney-Vento Act for unaccompanied children. The next is educational accommodations related to disabilities or other special needs. And the last one is issues relating to FERPA, the Federal Education Rights Privacy Act. So if you could just tell us how many cases you've handled, and, so we can kind of see if you're familiar with all of these.
Sure. Do you mind if I provide this to you now?
That makes sense.
Okay. Because that is something, this document answers that question squarely.
Okay, well, we can read this.
So let me,
Thank you. But
let me just tell you,
give us a
every
quick,
one.
short answer.
Yeah, every one of those matters. The unaccompanied children thing, I have experienced actually as a law clerk. I understand there are various items that come into play there that essentially correlate with what I'll call parens patriae, parental control of one's education and a guardian's control. Who is a guardian? You've got to get past that when you're dealing with unaccompanied minors issues. You also have to address that when you're dealing with divorced parents, separated parents. That is not uncommon.
Let me interrupt.
Yeah.
Are you saying you dealt with one case for the McKinney-Vento Act?
No, I've only dealt with it insofar as providing advice to federal judges. Here's what you ought to decide, Judge. I have never handled, that I recall, a lawsuit or administrative proceeding that addressed that. I can't warrant that, but I can't remember one.
Thank you.
As to every other matter that you just raised, I have many cases in administrative proceedings. I've dealt with these things before. Accommodations, student discipline, broadly speaking, the Administrative Procedures Act, Chapter 120, is something that agencies and school boards ought to consider when they want to give the most due process to official acts that may deprive someone of a right or a privilege. So I've dealt with that in and out of administrative proceeding due process, in and out of administrative proceedings, in and out of lawsuits, both state and federal.
What about the civil rights actions?
1983 claims, all you have to do is probably Google me.
Okay.
I've dealt, 1983 claims, it's nothing more than a statute under which a person can sue for a constitutional tort, a constitutional violation, and achieve attorney's fees. So it accompanies every constitutional claim.
Would you clarify to me on the student discipline issues, what your involvement is or was?
Sure.
Has been?
Okay, sure. Well, I'd urge you to take a look at my law review article that dealt with alternative education programs. I've been involved with providing advice to school districts, to this particular school board, various administrators and directors dealing with thorny issues of what do we need to do if I'm placing this child for 10 days or more in this alternative program. if I'm doing a school suspension or this particular, what I'll call exclusive program. A timeout, but still providing education. So I've been involved in many, you could call it due process hearings, that is in-house consideration of a complaint. You know, parents get to complain, and school boards from time to time will identify someone as a special master or hearing officer or something. And my role is to make sure that it looks like, that it gives all, that all the process that the board believes is due when you're, you know, with this discipline or that discipline. So thankfully, I don't remember one that went sideways and resulted in a lawsuit.
Can I ask something on that? In the 8 years that you were general counsel, 2008 to, did say 2016?
Yes.
Were you representing the district in all of these 7 cases for the, IEPs and the student disciplines you
Yes.
represented
Yep.
Duval County District?
Yes, yep. I call it working for the good guy. No, really, I say that in jest. But yes, it's only been for the school board / district and for board members.
Now, I'm confused now. So all right, you said that, like I'm not familiar with how Duval County schools are set up,
Mhm.
but, and you said Karen Chastain was their general counsel, but she really works from the general counsel's office. So the general counsel's office so would Karen Chastain, the school board attorney over, I guess, in Duval County, why would she not be doing these things instead of going to the general counsel's office? I don't understand the roles.
Well, and that's fine, and of course, she's best to explain it, but put it this way, I joined the general counsel's office in 2008. The school district was just like many of our different agencies and offices,
Okay.
didn't have its own internal attorney, okay? And really, it's only now got a chief legal officer. That's not a school board, you know. Let me just tell you this. Karen worked physically within the general counsel's office,
Okay.
and then, which was a fantastic decision by the school board, they came to the conclusion, we need someone physically here that can put all of their attention to providing advice to the board. So that happened, okay? That didn't change my work. I did as much school board work before than I did after. Because the general counsel's office in the city of Jacksonville continues to serve at the pleasure of that school board.
How long ago did Karen get put into that position?
I really
I'm
don't, I'm thinking maybe 3 years.
Yes, to the chair, it's about 3 years.
Oh,
Yeah.
It could be,
Thanks.
actually, it could be tipping towards the 4th year.
Yeah, it could
It
be
could
4.
tipping to the 4th year, and
Okay.
it's evolved since.
I mean, it really has nothing to do with us, but
It's
I was just
different.
trying to
No,
figure out,
it's
I was just
set up
trying to
to- yes,
figure
it's
out
set up
how it
differently.
works over there, okay.
Look, there's 67 counties in Florida.
Mhm.
There are 2 that are real anomalies.
Yeah,
Jacksonville is one because it's consolidated.
yeah.
It's consolidated, and then there's this one general counsel.
Mhm.
So it's a big, big office. It's almost like a Department of Justice, a civil Department of Justice for the federal government. But yes, and it is still, look, there are attorneys that join that office that are perplexed as to what it is, how, look, I'll give you this example.
Okay.
It is not unheard of for a board member or employee, or officer, director, whatever, from a school board or from any board that general counsel's office serves, that they have an in-house legal officer, but they reach out to you and say, I didn't want to ask so-and-so this question. Can you please answer it?
So essentially, it's like the board has a firm.
It has a firm, yeah. And it
Instead of
is,
having one attorney, they have several.
they have several. But really, it was a very, very good development to have, Karen's a very, very good attorney. A very good development to have someone staffed there. And the goal, and it will continue to be the goal, is that, you know, the general counsel's office is in lockstep with the chief legal officer. You're lockstep. So, and that's really how it functions. I think that's the intention of that function. So, yeah.
Okay, thanks.
Your statement just probably 4 or 5 sentences ago is a great segue into my question. Given that we are not one of the 2 anomalies in the state of Florida, how would you expect to interface with other state and local government agencies in your role as a school board attorney?
Well, let me call your attention just so you know, I put in this very self-serving last page, which talks about the strength of my candidacy, and I must point out my own grammatical error in the penultimate entry there, where it says capacity, confidence, and sheer will to bleed. Just want to let you know, I know that. This kind of tells you, under minimal learning curve, I'm not so self-aggrandized to think that there will be no learning curve. You're a lifelong learner in law, just as you are in life. I am blessed, and I think that I can bring to this board a very good network of relationships that I have with agencies and officials, very locally, statewide, and at the federal level. And I continue to call upon those folks that really are there to help. Give you a case in point. I've been a member of the Education Law Committee of the Florida Bar. County attorneys and general counsel and school board attorneys, they rely on one another. If you have good friends and reliable legal resources, you use them. Okay, and that is something that I can bring to this office. And you want to know what I would do so anyway, regardless of the resources that this particular office may have. And that's something that I think you ought to really take into consideration in this very, very important decision that you're making.
I feel that this next question is somewhat repetitive because you've given us a lot of this information already. What types of cases have you routinely handled for school districts in the past?
Yeah.
And you've given us quite a lot of that already, but if there's anything else that you'd like to say about that.
Yeah, so routine, this handout provides to you, and I point out that this is a sample. This does not mean, and there are some cases in here that the school board or a school district is not the entity that is a party, but it's on an issue that I think you ought to know and familiar with. For instance, pensions and bargaining and so on and so forth. You may hear that on the news and what Jacksonville is going through. I handled a very, very big federal lawsuit that is said to have saved the city $1.2 billion, and I do that thing when I say $1.2 billion. But you know, this suggests accurately that you'll see I just basically list a handful of administrative proceedings. And when you say routine, I've had many dozen administrative proceedings. And this does not mean that they're just teacher termination or administrative termination or anything like that. Included among these are, and I've highlighted them in bold italics. This one dealt with a charter appeal. This one went to the Florida Human Relations Commission, Commission on Human Relations. This one dealt with improper or shocking curriculum. These are just kind of notables I've dealt with. You'll see probably on DOA's website and on these various agencies' websites, put in my name and you'll see a bunch of school district. They're all school district and school board members. And other than that, the routine ones have been 1983, constitutional claims whereby a parent on behalf of a student challenges the constitutionality of something. They say, if you've been deprived due process, you violated my Fourth Amendment rights, search and seizure. Teachers and outspoken folks with First Amendment lawsuits. Those are fairly, I wouldn't call them routine. But I've had several of them. They're not here, but I've dealt with a lot of lawsuits against the school board.
Thank you.
Yep.
What do you think makes you the most qualified to be the Clay County School Board Attorney?
Well, I really do. I didn't just casually apply to this. I only live across the river. I'm not uninformed entirely of the troubled waters of the past. I really am. It sounds corny, but I know you guys are too. You're committed to students. I am too. Public education is just so vitally important. So, the question, I'm sorry.
Well, the question is, what do you think makes you most qualified to be the
Okay.
Clay County School Board Attorney? But I'll just add to that.
Yeah.
What makes you uniquely qualified with
Sure.
your
Thank you.
educational background and your work experience?
So, you need, every school board needs not only a competent school board attorney, a learned school board attorney, someone who has a pretty broad breadth of experience, not just having outsourced this dispute and that dispute, actually having handled it, having been before judges. That is something I think that you will find unique in me. I have a very, very, it's shown that I have a pretty good view of the bench's perspective, how a judge will consider something. That comes from working every day with federal judges over the course of 2 years, and then this last stint with an excellent district court judge in Orlando. That is vital to have that perspective, because it, long story short, reduces expenditures of time and effort, and money, of course. I have a point of view, as I said. Even when I would have to hire an outside firm, I expect them to take direction from me, not to report to me. That is something I owe to this board. And I'm telling you, I've done it before, I can save a lot of money and a lot of heartache doing that, so long as I have the latitude to do it. That is a point of uniqueness as well. I don't know that various folks that have worked in the school board attorney's office or in public agencies, like county attorney's offices and such, that truly have been the lead attorney, the guy or gal who signs pleadings and actually presents oral argument. I'm happy to do that, and I expect to do it. Even in certain instances where we have outside counsel, it's very important and very persuasive, I find, to judges, very persuasive to, for instance, PERC, the State Board of Education, to actually have the school board attorney delivering the argument, delivering the board's position, not a hired gun. Okay? That is something that I am uniquely qualified to do, haven't done it before with success. Knock on wood, that I hope it continues. Okay? I think that I have great confidence going forward. But another thing that I really do want to stress, it's not lip service that I'm providing with respect to truly being excited with this new era of leadership. There is a chance here. I know that this school district does great things and is poised to do greater things, to make up lost ground and beyond. Okay, I'm really jazzed about that. I want to be part of that. I like to go home. Yeah, I could have made a lot of money staying in private firms, and still, believe it or not, I'm still not making the salary that I made as a first-year attorney in a private law firm. Okay? But here's the thing. It's meaningful to me to go home at the end of the day and feel like I've done something good. I've done something for my community. This is up my alley. And I think that if you look at my resume and my history, it's not lip service. I'm committed to this. So I hope, and I know it's long-winded, but I hope that it gets worse.
Thank you. Well, do you want me to finish with my questions, or do you want to circle back?
Continue on, yeah, so that we're providing the same. If you wouldn't mind asking the same individual questions you asked the last candidates, pull that out and see what.
Who's the role of the superintendent of school?
Well,
I have some additional.
I really think that question that needs to be asked, because
That's good to know.
What was it? What was the
It was the
question?
role of the superintendent of school
yeah.
board. I think that would be foolish
That was
to,
answered.
we're running short on time, and I'd rather ask something that
Okay.
pertains to this particular.
I agree.
I want to know two things, and I'm going to make my question into two questions here. Number one, what is your feelings on the necessity of outsourcing labor for labor law? And the other thing, now I've lost, while you're answering that, I'm going to think of the second part of my question. I wanted to know your feelings on outsourcing for labor law, how familiar you are with labor law, and would you feel a need for us to outsource? Oh, the second part of the question is, what resources would you need? Would you want these, or ask that the school board have a legal secretary? What would you need if you were working for us?
So with respect to the labor law issue, am I familiar? Yes, I am. I have been part of long, hard fought negotiations with most recently the Jacksonville Fire Union. When it comes down to it, even when a chief legal officer outsources to a private firm for collective bargaining, you mentioned labor law, but for collective bargaining, it is, that's an area of specialty, and I know the best attorneys, best bang for your buck. I've seen how they perform and what they charge, and they know me. It's incumbent on the board attorney or the chief legal counsel to be plugged in and to provide advice. Under these circumstances, I don't sense the resources that it would take the school board attorney.
Really?
Well,
You do read the paper, don't you?
yeah. When it comes down to collective bargaining, it is a project, and it is something that likely, well, I know that it is outsourced as rule of thumb from various public attorney offices, I'll call it. That is general counsel for various counties and school districts and so on and so forth. With respect to labor and employment law, when that kind of perks up my ears to lawsuits, there are many policies. I wouldn't be surprised if yours has a policy where employment disputes may be covered and that there may be an opportunity to demand defense. I fully expect where my board and my agencies that I serve, I become very intimately familiar with insurance policies, such that where something's covered, you demand that defense. You're paying for it, you're paying for the insurance policy, so get the defense. And not, it's repeating myself, but even when certain things are outsourced, some of which may be outsourced even under insurance policy, you've got to be a litigator to know which ones you've got to keep a very close eye on. I'll give you an example. There have been in my practice various matters that we demanded a defense, and some part of the lawsuit comes under an insurance policy, other parts of the lawsuit don't. But when the parts of the lawsuit that are covered go away, guess what? The keys are handed back to you. Okay? So it's vital to be informed. It's vital to know your resources and use them well when it comes to labor and employment disputes, lawsuits, and when it comes to collective bargaining, to know the lay of the land. I do know the lay of the land when it comes to collective bargaining here in Florida.
And what resources would you expect us to provide?
You know, it's all dependent on that which the board wants. If the board is inclined to take a road, for instance, to bring things in-house, then that means the whole idea of bringing things in-house is that you hire assistant attorneys. And that relieves you, many times, with good leadership, that will reduce your overall expenses. Okay. I'm a fan of that, but that isn't my decision. That's the wisdom of the board to make these decisions. Where you don't have warm bodies and I'm not available and the board is exposed, it is absolutely vital to hire outside counsel.
Okay, thank you.
Ms. Conlon?
So, you've talked a lot about your cases within the district, and you've talked about your experience with litigation and arguing in front of the Supreme Court and the school board of the Florida State School Board and things, and certainly that's impressive. But litigation is a lot more expensive than settling. So what percentage of your cases did you litigate versus settling in some other way?
I'll draw your attention back to this. I have a whole section here which says litigation, avoidance, and counseling. To answer your question, in short, although I've dealt with a lot of lawsuits and dealt with a lot of administrative proceedings for school boards, this school board, the Duval County School Board, where the dispute, where I've been involved in the dispute pre-lawsuit, 95% of the time, I've avoided the lawsuit. Okay? It is almost, it's a rule of thumb, it's a presumption, that you can reach, you know, they say good mediation or negotiation, both sides walk away a little bit distraught, okay? As a rule of thumb, I'm most inclined, though I like to fight, to tell you the truth, I'm most inclined to resolve things in a sound business manner, if you want to call it that. Outside the specter and financial threat of lawsuit or an administrative proceeding, or to kick something to an agency to decide. I like to resolve things before we get to that point. And I'm telling you, 95% of my work has been committed to that, where you will not see a lawsuit.
Thank you.
We deal with a variety of contracts, obviously, with outside vendors. How do you, what experience have you had with contracts, not only in approving contracts or working with contracts, but then also rescinding contracts?
There again, I have a little section here where, under the litigation avoidance, where I write contract and construction disputes, and I point to some of those that I'm most pleased with. The biggest one that left a lasting impression on me was the construction of the Duval County courthouse. There were a lot of things that needed to be solved under lots of political pressure, financial threats. We brought it in for a landing, okay? There is, you know, when we terminate or rescind, that's a term of art, it's a legal term. The way I'll paint it broad brush is that I've not met a contract dispute that I've been involved in, dealing with construction, vendors, so on and so forth. I've not dealt with an authorized and enforceable contract where there's a dispute that hasn't been resolved. Okay? And it's been resolved through different modifications, some of which include both parties going their separate ways. And you could, I guess, call that termination.
So you've never had to litigate a contract?
No, I've litigated many contract and construction disputes. So, you know, some of these are listed here. My most notable federal lawsuit dealt with JAXPort suing for a bunch of contracts dealing with the Davis Point terminal. Here's the happy part: although we had to sue, and I'm the guy writing the complaint, with the help of outside counsel. We did need outside counsel. JAXPort walked away with $10 million. So very, very comfortable with commercial contracts and employment contracts. So, yeah.
Yes.
Tell me about your board certifications from the Florida Bar. What was required of you to obtain those certifications, and how do you see the board and the district benefiting from those certifications?
This is a source of embarrassment.
I couldn't hear her
Yeah,
question.
we can hear you.
I could not hear you.
Tell me about your board certifications from the Florida Bar. What was required of you to obtain those certifications, and how do you see the board and the district benefiting from those certifications?
Thank you.
A source of embarrassment, this is. Again, I mentioned that I serve and continue to serve on the Florida Bar Education Law Committee. I served on that committee when I was part of the committee that created certification. I myself have not pursued the certification, but I'm quite sure that what it takes for me is simply an application. Because education law certification and a couple of other areas of board certification are largely driven by experience. You know, if you've got the experience, then you've got the certification. It could be, and I'm not saying that it is, I have to look, it could be that that's truly all it takes for me, is to simply apply and with an applicant fee.
May I do a follow-up?
Yeah.
Ms. Gilman?
I still have a couple more, but if you want.
I'll get related to your question. I'm not a lawyer, so I just want to know, is this board certification something that you send in money and you get certified, or do you have to take a course, or what?
If you don't have, generally speaking, and this is really generally speaking with lots of areas of board certification. Remember, this is kind of a new animal, board certification. It's only come out in the last 8, maybe 9 years.
I just wondered if it's something you send in
Yeah.
money and they send you a board certification.
In some instances, and again, I can't warrant this because I haven't studied it lately, although I should know if I'm on the committee. In some instances, certification, if you've got the years of experience, if you've done A, B, C, D, you have to apply, probably have a sponsor to say, hey, what he just said, I can substantiate that.
Does it cost money?
Yes, it does, and it does cost money to, if you don't have the experience, and/or if you have to take continuing legal education credits,
Yeah.
that costs money.
Thank you, Ms. Gilman.
Can I-
I'm sorry.
Is there an exam for that too? You have to sit for an exam?
If you don't have the qualifications by service, by years of experience and what you've done, and so on and so forth, most, and again, source of embarrassment, I don't really know,
Just
if
as
I
a-
would have to sit for an exam.
I did a little bit of research on this prior to our interviews, and I guess the easiest way to compare it as an educator, I would, if I wanted to be certified, right now I'm certified in K through 6 education. If I wanted to attach an endorsement to my education, let's say in ESOL education, if I wanted to attach an endorsement in special education for ESE, anything of that nature does take additional education. Yeah, my certification costs money every time I renew it, just like anybody else's professional certification will renew. And there is a test involved as well. Or there is some, it may not be sit down, take this test, but generally it is.
Yeah. He said that
and
it
it's
wasn't
not
any
simple.
education, it's more or less a checkbox thing.
It's, other lawyers have other information about there as well.
Thank you.
Yeah, there may be a test, I really don't know, and I should.
I just,
Yes.
no, you still haven't finished.
What, is that another question or?
Yes.
Okay, let's rotate. Did you
I don't have any more.
Anybody else?
Go for it.
So I saw in your application that you've obtained the AV preeminent rating for the Martindale level. What's the process for attaining that rating? How does it benefit your clients? And what does that designation say about you as an attorney?
Yeah. So let me tell you, there's 2 things that other attorneys will know and recognize. AV, you've got to actually have peer review. Both your friends and enemies, attorneys and judges and so on and so forth who you've worked with, who've seen your work, against whom you've argued. It is very meaningful and impactful to achieve that. One other thing that is impactful that I'm very proud of being part of is the Chester Dell Inns of Court. That too takes a nomination. You've got the Chester Riddell Inns of Court. You'll see it on my resume. That is a group of very good attorneys locally here in Northeast Florida. That includes essentially all of the federal judges here in our Jacksonville division, as well as some of the greatest and most successful practitioners. I'm very happy and honored to be part of that. How is it helpful? Let me tell you how it's helpful. And this is truly meaningful to me. When I go into court, I can tell you, and sometimes you gotta toot your own horn. I'm gonna toot my own horn. These judges know me, and they know that they can rely on me. That does an awful lot for my client, to have the presumption of reliance. And guess what? Those who seek to interfere with my client's public chores, that is, there are a handful of attorneys from, locally or around the state who like to pick on school boards and public agencies, pepper them with meritless lawsuits. I've dealt with them time and time again, and I've actually gotten attorney's fees, I've gotten sanctioned in the past. My integrity and reliability is something that you can collaborate on. That's also something that I urge you to really take into strong consideration as you make the selection. Who among them will be known, a known commodity and a reliable commodity to the jurists around here? And I can tell you, very happy to have developed that reputation.
Still have any other questions, or Ms. Conley?
I just had one clarification. I wanted to clarify an answer you gave back on the question about the school board attorney's role providing counsel to individual board members and requests from individual school board members. I heard you say, not that you may have, but I heard you say every board member is entitled to advice and where asked, entitled to your opinion. And so my question is regarding that, if kind of on the, to piggyback on Ms. Karakas's question about if 3 board members were to ask you for your opinion, then are you only giving it to those 3 members? So is the responsibility incumbent on each board member on each issue to call and get your opinion?
You know, after a while, we will develop personal relationships. That's my intention. And you'll get the view and impression. I'll certainly do my best to give you an authentic impression and that you can rely on. My opinion, I've said it a couple of times here, my default is I will not express my opinion until asked. Over time, as we get to know one another, we will get to a point of comfort where it's just conversational. And I'm not talking just individually, I'm fine having frank and open conversations in front of cameras, as I'm having, recorded now. So my default is, the wisdom and opinions is that of the board. You act as a majority. I'll absolutely, I'm sure that maybe there will be times that I gratuitously offer my opinion. Don't do that before the board. I'll maybe gratuitously offer input simply because I'm a human being as we talk maybe individually or in small groups. So I do not, you are all entitled to the individual and collective services that I bring to bear. And where you want my opinion, I will share it with you.
Thank you. Ms. Gilhousen, anything else? All right, so with that, were there any questions you had for us, or have we answered everything?
I think that we've gone through everything. There was a dangling part with respect to Ms. Studdard's question about resources. I wanted to answer, I've seen casually, how things have developed with respect to legal services to this board. To answer your question as to resources, again, I like to be active. It is incumbent upon me to, where I don't know something, to research it. So I would need access to Westlaw, electronic research, likely a secretary or assistant.
Would that need to be a legal secretary or just a in-house secretary?
It depends. As long as I can remember, my assistant has been a paralegal. Okay, so it all depends on what resources you all want to commit to it. I'll tell you, I think I can handle quite a bit. I like to multitask. I think that I've done it with some success, at least in the professional world. I think my wife may differ when it comes to honeydews, but usually it is appropriate in my practice to have it be television.
Well, great, well, thank you. Thank you for your time today and the information you provided
Sure.
us. The board will meet February 2nd, where we will have discussion and possibly take action, and Mr. Roski will get in touch with you after that. So we appreciate meeting you and coming and spending the time, and I apologize that we were delayed.
Thank you very much.
Thank you so
I
much.
really appreciate it, and I do wish you the best. I see
Thank
good
you very
things coming.
Thank you.
I'm gonna shake your
Thanks
hand,
for
but
this
that's
additional.
what we got, elementary school, thank you for coming.
Okay.
Thank you, sir. See you again.
Nice seeing you.
Yes, sir.
I really am, I'm
You'll
sharp.
be next
Yes,
meeting.
sir.
Thanks for the information.
Likewise, thanks.
How about you texting her and telling her?
Thank you very much.
Okay.
Yeah.
Thanks so much.
I will.
Mr. Ross.
Thank you.
Thank you very much.
Thank you as well.
Good luck to you.
Yeah, good luck to you. I really do think.
Go ready, go ready.
There's excitement.
Very good.
So good luck.
Thank you.
Okay.
I will
Sir, thank you.
officially adjourn the meeting for our Thursday, the 26th.
We're back here tomorrow at 10, about